Alright, we are now on item 4, establishment of an independent legal aid authority. We have a paper from Deloitte. So it's a consultancy study on the feasibility and desirability of this, and we have got a paper CB bracket 4747 bracket 03 in March 2013. That's an executive summary of the report of a consultancy study on the subject. And there is another paper number CB bracket 4747 bracket 02, and is issued on the 30th of April 2013. It's a letter from the Legal Aid Services Council to the Chief Executive on the independence of legal aid. And third paper, CB bracket 4747 bracket 01, letter from the LASC to the Chief Executive dated May the 27th on independence of legal aid. Finally, paper CB bracket 4794 bracket 04 is an updated background brief on the establishment of an independent legal aid authority prepared by the Electoral Secretariat. So some of the discussions of this council on the subject have been set out in this background brief. And today with us, we have some deputations and also the administration team. First, we have SOCO and also the Law Society, and the paper is CB bracket 4794 bracket 05. We only have the English version, and it's issued on the 19th of June. And we also have Legal Aid Council Association, Hong Kong Bar Association, Hong Kong Confederation of Trade Unions. We have also received submissions from the following deputations: Hong Kong Federation of Trade Unions Rights and Benefits Committee, paper number CB bracket 4794 bracket 06, only Chinese version. And from Ms. Josephine Pinto, paper number CB bracket 4794 bracket 07, English version only. Also, Legal Aid Department Law Clerks Association, paper number CB bracket 4825 bracket 01, Chinese version only. And we've invited the administration, the LASC, and also all the deputations here, and they are all here. And first of all, a welcome to all of you here, including the administration's team, the LASC, and also all the deputations. The Secretariat has prepared an updated background brief for members' information. This is not a new subject, and we suggest that members should refer to that paper, because we have had many discussions in a panel on this subject. And I'd like to say this to the administration team and the deputations. You can put on the earpiece. Well, 0 is floor, 1 is Cantonese, and 2 is English. And for the number of times you may speak. All right, first of all, I'll invite the LASC, the Legal Aid Services Council, which will brief us on this paper. And then the deputations will be invited to speak, and each deputation will be given 4 minutes. And deputations do not have to repeat the points that you've already made in the written submission, because we've already looked at your written submission, and all the submissions have been uploaded onto the website of this council, and they've also been distributed to members. And if you have any further points to add to your written submissions, you can also submit them after the meeting. And I'd also like to remind you that your remarks at the meeting will not be covered by the Electoral Powers and Privileges Ordinance, Cap 382. And while you speak, please do not use mixed mode, because our interpreters will find it difficult. And please do not use mixed code. So first of all, I'll invite the LASC to brief us on the study result. All right, over to you, LASC. Madam Chair, I'm Eric Lee, Chairman of the LASC. First of all, I'll be very brief, and to respond to what you just said, I'm not going to repeat what we have set out in our paper, but then in preparing this report to the administration, we've engaged a consultancy, and the consultancy has also engaged 2 internationally renowned legal weight experts who have also given us a very valuable experience of the overseas jurisdictions, and also on this subject of independence. They've also looked at the setup, the independence of the framework, and also the institution, and also financial and operational independence. So these are the 4 areas that we have looked at. And also in compiling the consultancy report, the LASC has also set up a working group which liaised very closely with the consultancy. Yes, the consultancy report is entirely independent from us, but then in preparing the report and also the statistics, whether we were happy with them, and if we have any questions, they were very forthcoming in modifying and updating the information. That's why it's a highly interactive process. That's why in the end, well, the report has gone through very detailed deliberation. In fact, after 9 amendments, when the final report was out, there was 3 rounds of discussion by the LASC before we came to a conclusion. And at this juncture, I'll defer to the consultants who will brief us on how the report was prepared. All right. Thank you, Dr. Lee. Yes, Mr. Wen.
Good afternoon. I am a partner of Deloitte Consulting. I'm Karen Wen. I'd like to explain to you how the report was done. We received invitation of the LASC, and we started a 26-week project. First of all, we invited 2 very famous persons, Frank Stephen and another one, who were very well versed in terms of legal aid issues. They were experts, and they were able to let us know the legal rules and legal aid rules of different countries. And we have conducted questionnaire studies, and we also conducted interviews. We approached different quarters who had an influence on the system, and we allowed them to speak up. And then, according to the experts' views, and also we adopted an independent methodology to come up with the conceptual framework, and we looked at the 4 aspects. First of all, financial independence. We were trying to see whether financially the service could become independent, and secondly, operational independence, and number 3, governance or control independence, and number 4, institutional independence. We looked at different countries, as I said, to see how we could make a comparison. And in the end, we did a very detailed analysis, and then making use of the findings of the analysis, we came to the conclusion that for the time being, there is no immediate need to set up an ILAA or Independent Legal Aid Authority. Can I add something to the conclusion? I understand that the consultant's report is that there is no immediate need to set up an ILAA. Now, we agree that this may not meet the expectations and aspirations of the legal sector, but let me add here that the most important thing is to consider feasibility and desirability. We hope members can give these 2 some careful consideration. In terms of feasibility, in terms of financial arrangements, the consultant has clearly pointed out that throughout the whole world, there has been no financial independence for such an organization. So we cannot dismiss this as a small detail before we can find a good solution. And also there has been a voice saying that there should not be any cap to the financial resources. I hope members will give this very careful consideration. We would not agree to it for the biggest benefit of the applicants. If we have an uncapped financial arrangement, well, this would receive the applause of the world. But if we want to give that up in order to have an ILAA, I want members to consider whether this is in line with the public interest. Number 3. In fact, we need to really think deep into many issues before we can draw up the details. I understand I don't have a lot of time here, so let me be brief. In fact, the spirit of the final conclusion is that we wouldn't like to have any more debate on the direction, because the conclusion does not say that we object to such a proposal. I don't think we need to argue further on the future direction, and I'm not saying we should have more consultancy reports. Rather, I hope that we can find practical and concrete options which are implementable within a controlled environment so that we can take a first step. And then we can consider the next step afterwards. This is the main direction of the report. We need to have a consultative framework, and in fact how that can be organized is not subject to any restriction. The first question to ask is what cannot be done within the existing framework, and there is no necessity to change the framework before we can do anything. Thank you, Dr. Eric Lee. Now I'd like to open the floor to deputations, and then we'll allow members to ask questions. First, Society for Community Organization, Mr. Richard Choi. Chairman, members. SOCO is aware that the LASC and the administration have refused to set up an ILAA, and we find this very disappointing and regrettable. Dr. Eric Lee just now said that in the whole wide world, no other place has a legal aid system as in Hong Kong, that there is an uncapped financial limit. But this does not have to be done by a government department. If we have an ILAA and if we have non-civil servants, well, as long as it is a statutory body, the administration can still operate the body with an uncapped financial limit for the sake of justice or access to justice. Secondly, we must point out that as a body helping the disadvantaged, we do confirm the good work done by the staff of the LAD. And in fact, some of our applications have been supported by the LAD so that there was access to justice. But it doesn't mean that the system is free of problems. As the consultant said, that in fact some people have taken the government to court and that received legal aid as well. But at the same time, we also tried to take the government to court, but we did not get legal aid. Recently, we were trying to help street sleepers who were evicted from underneath a flyover, and we lost our application for legal aid for them. And we also had the experience of refusal by the Community Care Fund to help certain people, and we had wanted to have a judicial review, but we were refused. And then once when we were refused, we asked some legal counsel to help us voluntarily, and they wrote certain application to the High Court, and in the end we got legal aid. Now, we cannot say that the system now is prejudiced for or against the administration, but from our experience, if you say there have been cases for legal aid being granted for taking the government to court, then I can say the opposite is also true. Under the present system, I'd like to talk about public perception, especially people who are helping the disadvantaged. We do feel that for a government department to approve or reject legal aid applications, well, I can say that psychologically we find the system not independent, especially when we are rejected. This is a perception issue. And secondly, under the system now, we do not know how far the administration has participation. Like in 2007, the LAD was under the administration wing of the CS4A's office, but then somehow it was transferred to the Home Affairs Bureau. I don't know whether the LASC commented on the issue. This is quite a strange move. You could see that if the LAD remains a government department, then directly or indirectly, it will come under a certain policy bureau, and government policies will have an impact on the LAD. This is all the result of non-independence of the LAD, and this is not just perception, but this is real. And also we find it most regrettable that the consultant did not look at the issue in the light of access to justice. We think that the consultant has not approached the issue from a human rights point of view. We find that a problem. Lastly, Dr. Eric Lee said that we should take a step at a time, but actually at the end of the 90s, the LASC has already come up with a report to support independence. Now this is a big retrograde step. Thank you. The second deputation should be the Law Society of Hong Kong, Mr. Leslie Young. Mr. Young, good afternoon.
Ms. Chairperson, we have made the submissions in writing. The only thing I wish to add, I endorse the view of this gentleman just before me, that this is a step back, as you have mentioned just now before we address this committee, that this matter came into being sometime in 1998, and there have been many sessions about that. But for some reasons now, LASC initially endorsed this proposition about independence. For some reasons, there's a U-turn or shift of goalpost, and they say now we don't need that. And the gentleman for Deloitte, for some reasons, there's no immediate lead. That the point is not whether it's immediate or not. The point is whether there's a need for independence. This is the main point. And I don't see any downside in doing that. And both Law Society and Bar Association are quite adamant that the independence is necessary, not just as a matter of image. It's a matter of carrying out what the legal aid functions, what they're supposed to do, and they can't do that without independence. I leave it to Mr. Perry for Bar Association to address this committee further on that point. I've seen the submissions of the Bar Association just now, and we fully support the submissions of the Bar Association on that.
Okay,
Thank you very much, Mr. Young. Next, the third deputation, Legal Aid Council Association, Mr. Nelson Kwok. Yes, Chairman, members. First of all, on behalf of the association, I'd like to thank the panel for inviting the association to express our views here on whether we should have an ILAA. At the beginning of the month, our association did a questionnaire survey with our members, and the findings are that a minority of members did not comment. The rest would be split in exactly half, and that is for and against independence. With regard to the Deloitte report and the recommendations in that report, we would only agree with the point that it should not be for the HA Bureau to be the policy bureau overseeing the LAD. Apart from that, we cannot subscribe or support any other recommendations in that report. First of all, it is recommended that the LASC should recommend or make nominations for people to become the director of LA and DDLA. Our association thinks that this is just another layer of governance, so that council and staff of the LAD would have to face another layer of pressure.
In the end, that would only undermine the independence of legal aid. Our association is of the view that at present, the appeal mechanism involving the judiciary would mean that the appellant or the applicants have already been sufficiently protected, as Mr. Richard Choi just cited in the example, given the fact that they've managed to get independent legal advice, and also with the appeal mechanism in place, they were able to get independent legal aid. That's why for the existing appeal mechanism for legal aid, we believe that is working well. But then if we were to implement the recommendation by the consultancy, that is if there should be a review mechanism in place, then that would mean a duplication of resources and would be a waste of resources, and is not cost effective at all. As regards the suggestion that the LASC will be directly responsible for monitoring the beauty lawyers scheme, this will not be able to resolve the problem of the director who might have a potential conflict of interest, because he will also be representing the cases, because if they're representing both parties to the litigation, then it's obvious that there is a potential conflict of interest. And also, given the fact that the duty lawyers scheme and the office is operating independently, but then as all the staff are from the LAD, and they will also be transferred to other units in due course. That's why the current setup and organizational structure will not be able to enhance the independence of the duty lawyer. Finally, the consultancy appointed by the LASC has submitted these recommendations, and mainly they just talk about expanding the powers of the LASC. For example, the LASC will be nominating people to become director and deputy director of the LAD, and also the LASC will be reviewing the decision to reject any applications by the LAD. Well, all the powers would be taken up by the LASC, and they have been accepted by the LAC. We believe that there is a conflict of interest, and it also cannot command credibility or authority. All right, thank you. Next, we have the Hong Kong Bar Association, Mr. Nicholas Peary.
Chairman, I hope you don't mind I was speaking English.
Of course, no.
The perception from both the Law Society and the Bar Association is that the LASC has again deliberately sidelined the professions in these discussions. In 2009, the then chairman, Mr. Chan Mo-po, wrote to the chief executive, and I can summarize it nicely by saying, everything in the garden is rosy. 18 months later, he was busy writing, asking for supplementary legal aid thresholds to go up and OLAS thresholds to go up dramatically. So we're in the same situation again. Nice though Mr. Eric Lee is, unfortunately he chose to write to the chief executive first before inviting the Bar Association and the Law Society for their views on the Deloitte's report. And then, because of my personal connection with him, I wrote to him personally and said, can we have the terms of reference, please, and also a full copy of the report? That is not consultation, Mr. Lee. And the Bar and the Law Society are very angry about that. We think that Deloitte's have fundamentally misunderstood what they should have been engaged for. This committee, this panel has already decided that there should be an independent legal aid authority, and they should have been addressing the next steps forward as to how to get it into practice. And the report itself has serious deficiencies. For a start, we went to meet with them on the 12th of September and handed them judicial statistics which don't show exactly increased access to justice. The reverse. The figures have got worse. That's despite the thresholds or the financial eligibility limits going up. You see, for example, in OLAS, the limits for both civil and criminal have gone up by 52%. The Legal Aid Department will confirm there's only been an increase in uptake of 2 or 3% at most. You have a graph before you which shows an exactly almost flat take-up for legal aid and slight decline of cases since 2006. So the Deloittes have just not considered this aspect at all. They've brushed it to one side. They're accountants. They should have noticed that when the eligibility threshold for SLAS went up by 2.6 times, the uptake was 40% in new certificates. Perhaps Mr. Lee can explain through Deloitte's why it was out of 100,000 applicants since 2006, they've only interviewed how many? 1. Ridiculous number. They only did 110 paper interviews. And they rejected 19 of those paper interview applicants because they had withdrawn legal aid, their application. If Deloitte's were selling a Ford motor car and they wanted to sell more of them, they would want to know precisely why people had withdrawn from their contracts of sale for the motor car. So those are some of the statistics we want to draw out of the report. It's quite clear over the last decade legal aid has been moribund. That's the best way we can describe it. We say there's illogical about the risk of government interference. We can show quite demonstrably there are caps. There are effective caps, and Deloitte's write them out in their own reports. So why, logically, can we not have an independent legal aid authority when there is an effective cap already? So we find their arguments confusing. Lastly, and it's most important, how did they approach the judiciary? The judiciary are hearing the cases. They're the people that have to go to court on Monday morning and pray that they've got a lawyer on both sides instead of having an unrepresented party who they've got to carefully explain their rights to. You only need to look at civil trials in the district court. In the last year, despite the increase in fells, there are now 14% more or 13% more unrepresented litigant trials. So why didn't they consult the judiciary administrator and say, please put us in a report about what you think legal aid should be doing in the next period of time? Who did they consult successfully? That very nice retired registrar, Mr. Christopher C.K. Chan. He was the only respondent, just one again. Did they contact Grace Wong, the administrator of the Duty Lawyer Scheme? No, I have a letter from her saying they didn't consult her at all. Did they consult the Bar Pro Bono Scheme? No. Ms. Sekin said there were no consultations at all. So, in summary, the report has confused arguments, no cap, but capped legal aid, So what's the rationale as to why there's been no progress since 1998? That's what this panel should be asking now. We think there's a better chance of reform if the department is independent. We know that when it was under the Chief Secretary's administration, certainly from 2003 to 2007, there was no reform at all, no increase of thresholds. At least we've had that benefit with the HAB. So clearly, an independent legal aid authority is desirable and feasible, and this panel decided that in 2003.
Okay, Mr. Piri.
Thank you.
Yeah, time is up.
So in summary, a very badly directed brief from the LASC, and they've come to false conclusions and very poor logic to support them.
Okay.
We've set out it in quite some detail, in 18 pages.
Yeah,
Thank you.
We have it. Okay. We welcome members to read it. 跟住落嚟係第五。
Next, we have the first deputation. That's the CTU, Mr. Poon Hon. Well, the CTU agrees that we should set up an independent legal aid authority in processing application for legal aid. Under the present setup, there is a chance that there might be interference from the executive. We are also concerned that where there are cases involving the executive arm, then the LAD might be interfered with. Just now we have heard that in the review report it says that there is no immediate need for us to set up an ILAA. Well, by that it doesn't mean that there is no such need, because if we do not adjust the setup now, then in the future there are bound to be more cases that would involve the interference of the executive. We would also like to emphasize this here. At this stage, concerning the protection of legal aid for workers, there is a need for further reforms. We believe that there are three types of cases. At present, because of legal aid vetting on the eligibility, some workers, in fighting for their interests, might have their interests undermined. Well, at the labor tribunal, after they won the cases, very often the employer would appeal against the decision. And if the worker is not eligible for legal aid, then in the end, he can only give up. Because for the amount that he is after, it might be just tens of thousands of dollars, but then if he has to pay for the legal costs in court, that might be more than the amount that he would be able to get. And that might force some employers to take advantage of the legal procedures so that employees will not be able to get their claims or damages. And also in applying for payment in default, and if the employer refuses to pay, and if the employee wants to file for bankruptcy of the employer, and if the employee is not eligible for legal aid, then there is no way that they can do it, because they will have to put up a huge sum for legal cost before they can apply for bankruptcy of the employer, and the legal cost might be somewhat higher than the amount that they can get from the bankruptcy of the employer, and as a result they might be inhibited. In the past, we have seen different trades, for example, catering, construction, and even the beauty trade. Many employees have faced with such situations. And the third category would be industrial injuries. Very often, the employer would abuse the procedures and they would file appeals with the court. They do not admit that there has been industrial injury, and if the employee's assets have exceeded the eligibility limit, then once again they will not be able to claim the damages. So in these few categories of cases, we believe that consideration should be made to exempt the employees from the FEL, so that they'll be able to get reasonable safeguards or protection of their legitimate interests, so that the employer would not just take the case to court or file for an appeal so that the employees would have to face with such a huge legal cost, and then they would be inhibited. We hope that consideration can be made for reforming this part of the law. Thank you. For the Bar Association has also submitted a submission which has been tabled is in English only. That's paper CB bracket 4830 bracket 01. As the Bar Association representative has already highlighted their views in the submission. All right, now I'd like to call upon Ms. Grace Fu to respond to the views made by the deputations and also the LASC. So, Ms. Fu. Thank you, Madam Chair. The administration has received the recommendations made by the LASC and also the consultancy report. We are now studying the recommendations made by the LASC, and we will also be listening to the views made at the AGLS panel meeting. So we will consider all the views that are made here in determining our final stance on the issue.
Today, to assist members' discussion, I'd like to talk about 3 matters of principle. Number 1, at present, the LAD, through its professional team, provides legal aid services according to the ordinance. In enforcing the ordinance and also in its daily work, the LAD has safeguards to abide by, so it is ensured that they provide the service independently. This is confirmed in the report. Second point, in the legal aid ordinance, there is an appeal mechanism, and deputations have mentioned this. In the appeal mechanism, if an applicant is aggrieved by the decisions of the LAD, they can appeal to the registrar of the High Court, who can make a final decision. This is to ensure that legal aid work is enforced in an independent manner. Number 3, all along, the policy objective of legal aid service is to ensure that all substantiated cases would not be rejected for a lack of means. And there is a point mentioned by the deputations, and that there is an uncapped budget for legal aid. This is an important pillar in the entire policy, so that the LAD will only have to concentrate on enforcing the law, and that is whether the applicant has merit in the 2 tests, and it does not have to worry whether the resources allocated to it would be enough to support its work. And there will be no question of applicants being denied access to justice for a lack of means. Since this has been mentioned quite frequently, and that is whether indeed there is an uncapped budget for legal aid services, or is it that there is de facto capping? Now, Chairman, if you would allow me, I would like to ask the LAD to supplement. Yes, please do, Mr. Kwong. Thank you very much, Mr. Chairman. I'd like to say one thing. Just now, the Bar Association said that with regard to financial resources, there is a cap. But in fact, every year, we are not subject to any expenditure cap. This is very important for us. When we process cases for legal aid, we just look at the justifications. We will not consider monetary resources in approving or rejecting applications. Therefore, the absence of a resource cap is instrumental to the policy. Right now, we do not have to worry about not being able to pay legal fees. It is not an issue for us. Is that all? Okay. Now, I'll allow members to speak first, and later on we can have follow-up by other parties. 4 members, Mr. Wong Yuk-man, Mr. Lee Cheuk-yen, Mr. Ronnie Tong, and Mr. Leung Kwok-hong have raised their hands, and also Mr. Martin Liao, and also Mr. Dennis Kwok, and also Mr. Chen Kam Lam. I will give each member 4 minutes. Mr. Wong Yuk-man is not in the room. We'll get Mr. Lee Cheuk-yen to start. Ms. Chairman, this issue has been with us for many years, and now you still say there is no immediate need. Well, even if we have an immediate need for universal suffrage, we still do not have it. I mean, you need to do what is right. You should not just say there is no immediate need. In fact, we are most concerned about political influence. That is why we want an ILAA. You can, of course, say there is no political influence, so we do not need an ILAA. But frankly, who knows if there is political influence? Now, of course, you can also say even if you have an ILAA, the appointments are going to be done by CY Leung, and the problem will remain. Well, yes, of course. But if you look at the system, if you look at the framework and Hong Kong's future, we would expect the administration not to interfere into the system, and the framework must provide the safeguard. And of course, in making the appointments to the ILAA, we must also consider whether the members appointed are independent. But let us be concerned about the first part first. Conceptually, we should have, first of all, an ILAA. Now, there is something I don't understand. It seems Dr. Eric Lee is turning this into a purely technical issue. You are asking us to look at desirability and feasibility, and then after that, you talk about practicability. Well, you are throwing these jargons at us, but if it is just a technical issue, why can't we deal with it technically? And if in principle you think this is a good suggestion, then you can find technical solutions to technical matters. But now it seems, even if it is okay in principle, but there is no immediate need, so you want to approach the issue in a technical manner. So are you trying to procrastinate on technical grounds? The LAD or the Bureau concerned. If you can allow me to respond, I can respond now. Yes, please. If we say there is an immediate need and we should embark on it immediately, then we have to tackle implementation issues in a short period. In fact, there are technical issues. In 1998, the consultant said that it should go ahead, but then actually it proposed 4 different models. Now, which one should we choose? How should we go about it? And before we could make up our mind, it would be difficult for us to make a suggestion to the administration. As the council, I think we should think deeply into it. And the Law Society just now said, or actually the Legal Aid Council Association said, well, we never mentioned review. The consultant did not mention review either because the law does not allow it. We are just here to do oversight, and there has already been a lot of resistance. And if you are talking about changing the mode of operation to increase our oversight function, we really have to take this up with the civil service. And if there is no immediate need, it doesn't mean that we won't do it. But I would like you to allow us to take the first step first, and that is to enhance transparency and also step up our liaison with the stakeholders, and then we can decide on a certain model, and then we can go to the next step. So there is no roadmap, no timetable. You say you would take the first step, but what is your direction and what is your final destination? We know nothing about those. You may take your first step, but you can stop there, and then you're going to procrastinate even longer, and I'm disappointed. Next, Mr. Ronnie Tong. Chairman. Sometimes we don't know why we are discussing issues here at LegCo. Mr. Eric Lee said there is no immediate need. But Chairman, we have waited for 20 years. This was first mentioned in LegCo in 1993, if I remember correctly. It was the 21st of July. And give us 20 more days and it will be 20 years. The administration, of course, says there is no immediate need. But we have waited for 20 years. Last time there was a report saying we should do it. And now it should be the time for us to consider how to do it. But we are going back to the first step and you are still questioning whether we should do it. And now the result is we should not have to do it. So what have we been doing in the last 20 years? I think it's a waste of time for us to have devoted discussion to this matter. Now my question is, one of the main reasons for asking for an ILAA is about the perception that the LAD is not independent. We are talking about perception, and we are talking about the views of the public. It is not the view of Dr. Eric Lee or any other member of the LASC. So why don't you consult the public? And how are you going to tackle this perception problem? This is not a question for the consultant. I'm asking the administration, how are you going to tackle this perception problem? And it has been 20 years. How can you answer the question that you are starting it all over again? It's like playing Monopoly, and in the end, after a certain time into the game, you are back to square one. You are talking about the achievements of C.Y. Leung. I think it's an insult. It's an insult to us. It's all right. LegCo members can be insulted, but please do not insult Hong Kong people. How come after 20 years you are going back to step one? How can you answer to the public of Hong Kong all the questions raised by the Bar Association? None of them have been answered. Deputy Secretary, Mr. Ronnie Tong said that we have to face this perception problem. Please speak into the microphone. Sorry, yes. The questionnaire survey conducted by the consultant is such that members of the public were concerned about the quality of the legal aid service instead of whether there would be an independent authority. We are relying on the consultancy report and the views of the council as the basis, but we are here to listen to the views of the deputations and members. To tackle this perception problem, what step should we take and how big that step should be? If members have different views from the LASC, we'll take them on board. Well, Chairman, the administration is best at not accepting views of independent groups like the LRC. So would you also reject the views of the consultancy? You can say you don't accept it and then you can make your own decision. Let the C.Y. Leung government do something good, please. All along, the LASC proposals are such that you always mention the 1999 consultancy report. At that time, the administration did not accept that report. Yes, please continue. I'd like to say something more. No, I'm asking you whether you would also reject the consultancy's report this time around. Well, we explained in 1999 that we could not allow a non-government body to receive an uncapped budget. And that is why we said the core issue really is to allow the present services to be subject to no cap of financial resources. And also in 2009, the LASC did its own study, and they proposed that the status quo be kept. So you can see that the LASC conducted different studies, and this time around it is quite a lengthy study. No, she did not answer my question. No, she did not. We will try to see how members follow up, and we can ask the question later. Mr. Leung Kwok-hong, Mr. Ronnie Tong, you are foolish. You can just call them a sour loser. That's it. In the UK, there is this famous writer. The grandfather was saying to his grandson that you can have a choice of your girlfriend, but as long as that girlfriend is also the apple of my eye. This is what the administration is doing.
So, in your report, you can just insert this. That is, if you're concerned about the adequacy of the service of the ILAA, then you can also put in this additional question. That is, if there is an independent legal aid authority, then would you find it more acceptable? So it's about whether or not you would be prepared to accept the decision by an authority which is operating behind closed doors. So when you go about your consultation, I think all you need to do is to include this as one of the questions. Then I'm sure the public will say that if I'm concerned, if I have worries, then I'd rather have an independent authority providing the service. I think the problem is with you. If you're refusing to accept the initial report, and then you're actually doing even worse because you're actually putting the LAD under the HAB. So actually it's under tighter control by the executive. Yes, you said that you would be acting fairly and impartially, but then it's about justice. And, well, by that, it's not just about whether justice is served. It has to be seen to be served, and there has to be checks and balance. How come there is an executive arm controlling this department, which should have run the service independently and impartially? In particular, it's about whether the public will have access to justice with public funds. It's about judicial relief offered to the public. All right, if I'm sued by the DJ, and then if I claim legal costs, then the court or the judge will say that, sorry, you've acted suspiciously, and that's why you've been arrested by the police. All right, I think you're also casting doubt on yourself. Definitely, if you insist on doing that, then there would be this perception problem. Or if you say that the public are only concerned about the level of service, they are never concerned about the independence or otherwise of legal aid. I don't think that's true. So, if the government had been wise, then you should have learned from the moral of the story when justice was put to the cross. All right. So you can wash your hands, and then whether or not Jesus should be condemned, I don't know. It's for you to say whether or not Jesus is should be found guilty. All right, so long as it's made independent, it's okay. Whether or not there is a cap on the budget, that's another issue. But then once a decision is taken, then somebody will tell you as to what you should be doing. If you go about the consultation in that way, then you might say that, all right, there should be a cap on the budget, or else they will be spending every dollar given to them. So you should have your own stance first. Next, Martin Liu. Thank you, Madam Chair. Well, actually, I was about to ask this question, and that's about the Deloitte report. In the final report, well, I've read the executive summary, and there is an argument here. So, Madam Chair, please allow me to rephrase it in Chinese because I'm reading the English version. Apparently, it says that, well, all the stakeholders that have been consulted apparently feel that with regard to an independent LAA, they believe that it's desirable and feasible. But then they contradicted this argument by saying that, and yet there are other uncertainties involved. And they've set out 2 points here. And the first point is with an ILAA, then in discharging its duties, there might be a lot of external pressure, in particular political pressure. So I'd like to put this to Deloitte. Is that their wrong assessment or is that their wrong conclusion? And if it's an assessment, on what basis have they come to this assessment? Or if this is their conclusion, then why have they come to this conclusion? Is it that it's their view that if it's a government department, then they would not be subject to such political pressure? Mr. Wen? All right. To respond to what Mr. Liu just said, well, let me also supplement on Mr. Leung's question. In designing the question, actually we asked the public, all right, at present in the LASC, is it enjoying adequate independence? 58% said that it's adequate, and 16% said it's inadequate, and 15% said no comment. And then we asked an additional question: is there a need for increasing the independence of the LASC? 61 said yes, and 29 said no, and 9% said no comment. So our interpretation of the replies to these two questions is, well, I can draw a simple analogy. All right, on the first question, we ask you if you have enough money, and they said that yes. And we asked if you want more money, and they said that yes. And there is no conflict between the two. In the end, of course, we do not just rely on such surveys. We also look at different comments, including overseas experts, and also we've looked at overseas jurisdictions and so on before we came to this conclusion. On the last point made by Mr. Martin Liu, that is after we have been made independent, would there be rather interference? Well, when it's turned independent because of the different setup, is no longer within the government, well, as it's going to be a private operation, then there might be more external interference, because when it's a government setup, then relatively speaking, it's operating independently. Mr. Liu, as you can see now, the government is subject to a lot of political pressure. This is for all to see, and apparently your conclusion, or the implied conclusion, is that if it remains a government department or government body, then it's easier for it to resist such influence or pressure. But then 8 years ago, we have already got a very influential person telling me that, civil servants, even if they are walking beneath a balcony, they would also have to put on a helmet. So I think it only goes to show that if it's an independent body, it would be better able to withstand such pressure. Would that be the case? Well, let me supplement on that. Well, just now you also referred to the case of a civil servant. All right, I'm not a civil servant myself, but then I'm sure civil servants are very clean, and they would just do their jobs without any political objective or motive. But then if it's an independent body, then with a different chief executive officer, they might be subject to more pressure. If it's a private entity, I don't see how come you're calling it a private entity. Well, if it's an independent body, then it's operating like a private organization. Next, Dennis Kwok. Thank you, Madam Chair. Well, I think the deputations have already given their assessment on the report. I think they have been too modest. I think this is really rubbish. So how much have you paid Deloitte for this report? 380,000? Close to $3 million. $3 million. close to $3 million. $3 million for this report? Madam Chair, I'm shocked. You have to spend $3 million taxpayers' money for this rubbish report. And if you put this to Josephine Pinto, it's your own person, and she has written in, and she said that this is an outrageous report. This is completely nonsense. And back in 1998, you already said that you needed to have an independent LAA, and in 2003 too. So what has changed to make you suggest that there is no immediate need? There is none. And still, you have spent $3 million taxpayer money. I've written in March. That is, I'd like to get a copy of, that was in October last year. So can you give me a copy of the instruction that you gave to Deloitte? Can you give that to me now? Madam Chair, well, a few members asked me for a brief for the consultancy. It's a brief. It's not the terms of reference. Well, before we submitted it to the Chief Executive, we believe that it's not appropriate for us to give a copy to you. But then, indeed, after it's been given to the Chief Executive, the entire report has now been uploaded onto the web. But then when you instructed the lawyers, what's the letter that you wrote to them? Well, the Secretariat has been instructed to provide copies to all the parties concerned. All right, can you give a copy to this panel? It's not a problem at all. But then according to the records that I checked, Mr. Kwok did not ask for the executive brief, if I remember it correctly. All right, for the panel, we did give a copy to this panel. Well, I'm grateful to the Bar Association for the document that they gave us. I hope that I'll give them the rest of my time, so I'll give the floor to the Bar Association representative. I'd like them to tell us what they're most unhappy about the report. Mr. Piri?
Please.
I think the first thing that is very unfortunate, I would invite Mr. Eric Lee to reread Section 4 of the Legal Aid Services Council Ordinance Cap 489. He said it wasn't part of their function to review the work of the department, and it wasn't part of their function to review their activities. Subsection 2 says, the Council may formulate policies governing the provision of services by the Department and give advice on the policy direction of the Department. B, review the work of the Department from time to time and make such arrangements as are expedient and proper to ensure the efficient and economical discharge of the functions and the provision of legal aid services by the Department. C, to keep under review the services provided by the Department and the plans for the development of the Department. That's what we're complaining about. LASC has done nothing since 2003 until we provoked the Bar Association and the Law Society in this panel started the series of debates. I've been to, I think, 13 of these, Mr. Eric Lee, and you've just not moved until 2011. Just that's on the financial eligibility limits. So that demonstrates that this whole situation and whole relationship is a sort of cosy friendship, don't rock the boat sort of situation, and don't develop the scheme. The second thing I want to make very clear is that paragraph, let me get the correct paragraphs numbers. It's paragraph 60. It's quite clear. This is Deloitte's report talking about the financial dimension. Paragraph 63, LAD is funded by the government and is therefore not financially independent of the government. However, there is no overseas jurisdiction observed in this study that doesn't rely on any government funding. The focus of independence, of financial independence, should relate more to the legal aid body's ability to receive the level of funding required to meet its legal aid costs, as well as its freedom to allocate its funding within given limits. And then they comment, although expenditure on legal aid services is uncapped, the Legal Aid Department has maintained a stable trend in expenditure and granted similar numbers of legal aid certificates over the past 10 years and not sought supplementary provisions. That is precisely why the Bar Association and the Law Society are complaining. Legal aid has been static. The budgets have been static, more or less. There's been 4.6% compound inflation since 2006. No reflection in increase in budget. The Department of Justice budget used to be on a par with the legal aid budget, about between $500 and $600 million each year. Now, the Department of Justice budget is $1.7 billion, and legal aid, I think, is just creeping up to about $700 million. So that gives you the extent of disparity and lack of funding given to legal aid in the past decade. So there is a cap. Somebody is forcing down the numbers, and we want that changed. And we don't think that pushing the Legal Aid Department from the Home Affairs Bureau back to the Chief Secretary's office will make one jot of difference. You need to get to grips with the basic problem. There has been no really impressive legal aid reform probably for the last 15 years.
Okay, thank you, Mr. Piri. 跟住呢就係陳鑑林議員。
Thank you, Mr. Chen Kam Lam. Thank you, Chairman. We have heard the views of many colleagues. Some are for, some are against making the LED independent. We're entitled to our views, but we must show mutual respect. I believe Deloitte has been selected by the LASC through a proper process. Whether or not you agree to the report, well, you can point out what you do not agree with and how the report is imperfect, but there must be mutual respect. Just now, some members said that this is a perception problem and they wanted independence. I think what is most important is that the work of the LED, practically and also in terms of the quality of service, now we should look at these two to see whether there are problems. I think this is the most important thing we should look at. If all along, if the LED has not done a good job, that the public are aggrieved and they had hoped to get the services of the LED but they were denied the service, then of course we should review the LED and to see if we should bring in improvements and whether we should go for an independent mechanism. But it shouldn't just be a matter of perception. And we should not change for the sake of change. Let us not get it wrong. Certainly, very often civil servants would tend to err on the side of safety, but they also follow a civil service code. We, of course, do not want government departments to do whatever they want. If we want an ILAA, which is outside the civil service and which does not have a financial cap, but which uses public money, I think as a taxpayer, we might not find it safe. Chairman, I'd like to ask this question. Throughout these years, well, just now the Bar Association has also criticized that you have only expanded your budget by a very narrow margin. I'd like to ask the LAD, is it that you really had to submit to a cap? Has there been any increase? And would you also put caps on cases in which the government was taken to court? Whether it be the LAD or the administration, I'd like you to give me more data and figures to reflect reality. So should we go for some change? If you have not done your job well, then yes. But if you have done your job well, why should we go for any change? Also, we know that the staff of the LAD are worried about what happens after independence, whether they can have job security when they will be out of the civil service, and what are their job prospects. I think we need to take care of that as well. Can I have an answer to my question, please? Some figures about your expenditure, especially with regard to cases in which the government has been taken to court. Chairman, I can answer that question on behalf of the LAD. I'd like to thank Mr. Chan for that question. First, I'd like to clarify again that the LAD, in terms of our legal cost, there is no cap. Just now, the representative of the Bar Association also said that it seems our budget has not really changed. But I think they do not understand something. Every year we make an estimate, and we will be monitoring how much legal fees have been spent, and we will also make an estimate as to which cases would be more expensive, and then we can increase our budget estimate. But then the fact is that there is no cap. Within the LAD, when council tackles any case, they would not think about a lack of resources for carrying on with litigation. There is no such a problem. I think I have to clarify that point. Why don't you tell us which case cost you most, how much money was involved, and what nature of case it is, because this has to do with perception as well. So can you not let us know the most expensive case you have handled? Well, I can call to mind the right of a boat case in 1997. We were talking about an expenditure of almost $40 million. What about the Hong Kong-Zhuhai-Macau Bridge case? How much money was spent on it, the judicial review case? I don't have the figure for the Hong Kong-Zhuhai-Macau Bridge JR case, but it is not a small figure. I can supplement that information. I do not have the figure with me now. Later on, we can come back to this because we have members standing in line to ask questions. Mr. Chung Kwok Pun. Thank you, Chairman. In Deloitte's report, it is said that 2 experts were hired to look into 9 jurisdictions practicing the common law. But then you did not mention how they were compared. You said that the strengths and weaknesses were compared, but we were not shown how the comparison was done. And how can those places be compared to Hong Kong? That was not given either. Could I know where the details are? Okay, who would take the question? Mr. Wen? In fact, in the full report, the comparison is included. We have looked at Finland, New Zealand, the UK, Northern Ireland, Scotland, Ontario in Canada, New South Wales in Australia, and also the Netherlands. They are of 3 different setups. One, a government agency that is in Hong Kong, New Zealand, and also Finland. Secondly, NTDP, Ireland, Scotland, and also Canada and Australia. And the last one, a fully independent setup. This is found in the Netherlands. Professor Alan Peterson and Professor Frank Stephen did different comparisons. Some of the countries were thinking of turning their setups into a government agency, including the UK. This is because of financial difficulties encountered, and they would like to put the agency back into the government structure. Mr. Chung? Chairman, this was just given to me and I would have to read it afterwards before I can ask further questions. Okay. Ms. Anne Chiang. Thank you, Chair. If something has to be changed, if a structure has to be changed, first of all, we must find that the present is problematic, so you want to bring in change. But I have read everything and I cannot find any signs of the present setup in that there has been government influence on the legal aid system. And in fact, the biggest amounts of money has been spent on cases taking the government to court. Members of the public and my friends are asking why the administration is giving so much money to council to take itself to the court. And when these cases are brought to court, the administration also has to hire its own counsel to respond. And maybe millions, hundreds of millions of dollars have been spent on such cases. And in fact, members of the public do want to quibble with this. If you want to consult the public, I wouldn't disagree. In 1998, the LASC made a proposal that there should be an ILAA to take care of legal services throughout the territory, and the LASC would be able to employ its own staff without getting civil servants to help. And the finances would still come from the government. And again, there will be no cap to legal aid expenditure. Well, I would say that members of the public would prefer that the system remain within government, so they will be more reassured. But if it is an independent authority, who would be the staff? Well, we can allow Mr. Ronnie Tong to work there, but then I might find it unfair. But if I would be hired to do it, then Mr. Ronnie Tong would think it is unfair. So if it isn't found to be broke, I don't think we should mend it. Dr. Eric Lee? Well, Chairman, a lot of issues have been raised. I'd like to make a brief response. When we read the report of the consultant, we place emphasis on the fact that it has been objective and it has based its findings on actual data, so it is evidence-based. We have looked at their surveys and figures. Well, you can do consultation on end, but the accountants have acted in a scientific manner, so they have drawn this conclusion. And in fact, the report has given us a lot of valuable input in terms of overseas experience, so I think it is good value for money. Yes, there is no controversy that we should go in the direction of more transparency. But as from Mr. Chung's question, you can see that the countries are evolving. The UK and New Zealand are actually going back on the structure. They would make their authority and a government department. And in fact, even within the British Commonwealth, they have not just gone for independent authorities. And just now there has been some criticism about the governance structure. As Mr. Peary was saying, and he was right, that in fact there is a lot of latitude in the law for the council to make reforms so that there could be more monitoring and oversight. And also members asked about figures and data. Yes, we can release more of them. We can discuss with the administration as to how that can be improved. And just now the panel asked for a lot of information. But as far as I know, when the report has been submitted to the CE, we have responded to all the requests. We have given this very thick report to the Secretariat, even though we did not issue it to members. In September 2012, I came to the post, and just now the Bar Association asked many questions, and it said that we did not answer, but that was not known to me. But I would be quite happy to work with them from now on, and we would be very happy to listen to their views. Members, it's now 5 to 7, and I have the discretion to extend the meeting by 15 minutes because we still have members speaking in the first round, and Mr. Dennis Kwok would like to have a second round. I would therefore exercise my discretion to extend the meeting by 15 minutes. Next member, Ms. Emily Lau. Sorry, Chairman, I must apologize for my lateness in coming to the meeting. This is a great concern, and I believe our guests have heard members, and you would understand why there has been no change in the last 20 years. I believe there won't be any change in the next 20 years either. I find this very regrettable. DS, you said that one of the reasons was that there is no cap to the expenditure. But if you look at the Bar Association submission, it says that at the LAD, in fact, there is a cap. So do you think you have answered the question of the absence of a cap? Of course, they say the entire system should be reformed, and I agree.
點解啲錢係好似一路都唔係加得咁多？同埋其實喺實際上咧，而家都係喺個開支嗰度咧係有上限嘅。
好，係副秘書長。
非常之重要。我哋希望會後咧同處方咧再提供多啲實質嘅資料俾大家。就因為法援嘅開支咧，其實係我哋叫做需求主導，即係你係睇當年其實係咪有咁多合資格嘅人呢係獲得法援處嘅批准打。
We have to see if there are applicants who are eligible, and if they fight all the way to the Court of Final Appeal, and if you lose the case, then the implications would be rather significant. Well, the example that was cited involved a cost of some $40 million. At present, it doesn't have to worry about it. It doesn't have to worry about the funding provided by the FC. All right, at present, the funding level is adequate. It shows that when we prepare the budget, we have been very careful in preparing the budget, and that could also be verified by the department. We would look at cases that might incur high costs, and then we would prepare our budget accordingly. So as a result, we have never sought any supplementary provision. That's why. Indeed, if you look at the annual spending, all in all, there has been a steady growth, but then there might be a modest drop in a particular year. That's because during the previous year, the spending might have been rather high already. And the reason why we have elaborated so much on this, well, that's because the Bar Association apparently had this view. All right, in practice, you have this cap in practice. And all we are trying to say is that's not true. That's not true. In fact, there is no cap at all. And as a result, the LAD has been able to look at the merits of the case in approving the application so that the litigants can take their cases to the court. And that's very important. And I would also have to take this back to the long-standing government view. Back in 1998 and 1999, we did not accept the recommendation for the LAD to be made independent. In fact, there were several reasons. One of them being, well, Deputy Secretary, please speak to the microphone. Well, the administration simply cannot provide an uncapped budget to an independent body. According to the suggestion by the Bar Association, all we are trying to explain to them is, according to your understanding, yes, in practice there is a cap. That's not true. That's not correct. What we're trying to say, all we are trying to say is that that's not true. But then in one of your conclusions, you said that why don't we set up an ILAA and then you would be prepared to accept a cap on the budget. But then, as to whether or not the LAD is subject to a budgetary cap, well, if your understanding is that, then we don't know if you're prepared to accept an ILAA with a budgetary cap. So we'll provide you with further information. Well, in fact, the administration is also asking whether or not there should be a cap on the budget, and would you be prepared to accept it? And also, your view is that there is an actual cap, but then can you provide the information to us, because time is limited, and the Bar Association might wish to respond further, but then time is running out, so we simply will not be able to resolve this problem. Yes, I'm also on the queue. I think perception-wise, well, at least since the last term, when I've been taking part in the discussion, we've been talking to the HAB, we've been asking for additional resources. Apparently, there's not enough funding, and then they said that well, they've already managed to increase the funding by $100 million, and there is no way that there is no cap at all. So what's the perception? I'd like to understand it better. Well, our perception is, well, the very first motion debate that I moved was about legal aid and how that can be improved. For example, for the Lehman Brothers mini bond saga, or many of the small retailers or the investors were not able to take their cases to the court, and whether there have been negligence on the part of many of the institutions and so on. And we said that the pie should be broadened. And if a single case could cost $40 million, then how about the other applicants? Would they be able to get legal aid at all? Well, our impression is that there is no way that there can be no cap. All right, let's say if there are two major cases, then you could spend 80 or 90% of your budget. And then for the other minor cases, then so what do you mean by saying that there is no cap at all? Are you going to have a surplus from previous year that you can use as a reserve? So that's my first question. And secondly, I'd also like to give you this chance to answer the question, because just now, many participants of the meeting said that you were not independent enough, because in the past, you might not have been able to act entirely independently. So can you prove that in approving applications, you have been entirely independent? How come they have this impression that you had not been entirely independent? And also, Mr. Kwok Singh also specifically referred to this point. Well, he thought that there might have been some potential conflict of interest. Have you heard him fully? And if you have not got his point fully, then I'll allow him to speak again. And fourthly, I'd also like to follow up on this. All right, there is a new suggestion that the HAD should transfer this back to the administration wing of the CS for administration. So I'd like to follow up on these points. So can you answer these few points? Well, I'll answer the first and the fourth question, and then for the second and third question, I'll see if the chairman or the deputy chairman would like to take them up. Well, by an uncapped budget, let me explain. Well, when we accept the recommendation by the LASC, that is for the OLAS scheme, when we increase the funding, we are actually considering the implications involved. If there needs to be increased funding, then we will have to get enough funding internally before we say that we can accept this recommendation, and then we're prepared to implement it, or else this will just be an empty talk. Because if you are not supported by adequate funding, then it cannot be done. And in the past years, we have done a lot. We have enhanced the financial funding for the OLAS and also the SLAS. Well, that's the part concerning the OLAS. But then for SLAS, as is a self-financing scheme, after the resolution has been passed, specifically, in December last year, we had to go to the FC for an additional $100 million for the SLAS scheme, so that for certain schemes that have been approved, after the scope has been broadened, we will get sufficient financial resources for that. That's why very often when we said that there is an uncapped budget, we're actually referring to the OLAS, the ordinary scheme. As to the fourth point, whether or not we have already accepted the recommendation by LASC, actually we are still considering their recommendation. Dr. Lee, what's the second question about the independence or otherwise of the LAD? Because they have repeatedly asked for independence of the LAD, and also they also alleged that there had been conflict of interest. All right, let me be brief. in my reply. All right, for the perception that is not independent is not an easy problem to resolve. We will not be able to address all the concerns raised by Mr. Kwok, that's true. But then for the advisory committee, we can step up the monitoring role played by the advisory committee. That's what we can do. And we can also assist the government in disseminating the information more effectively so that there can also be more systematic analysis of the information, for example, on the independence, whether or not there is any cap on the budget. Well, that's what the advisory committee can do. So that's the direction that we have taken. But then on the perception that, we will not be able to resolve the problem entirely. And if there is any doubt about this, very often they will have to go to the court. They can file appeals. And then for the minor cases for the official solicitor, well, they will have to seek advice from the private sector or the private practitioner in giving advice to the department. So in terms of the actual operation, to a very large extent, it's very independent already. And therefore, when we consulted the stakeholders and the applicants, they did not feel that independence is an issue. In fact, for all the politically sensitive issues, it's been pointed out that the legal department never rejected any of those applications. In fact, all the applications were granted. So the facts speak them all. So if you look at the actual operation of the LAD, which is run by civil servants, well, there is no evidence to prove that it's not independent at all. In fact, that has actually helped them to explain their policies to the public more effectively. And also, we have also helped the administration in setting up independent bodies and so on. There would be some difficulties. Yes, the administration might say that, well, even if the administration is willing to do it, now the administration is not willing to do it. Even if the administration were to allow for an independent body to be set up with no cap in its budget, and if there is a significant growth in the demand, and if it runs into deficit, then I'm sure the auditor would not have approved the accounts. And if they want to apply for new money, all right, if it's a government department, then it's easy for them to wire the funds within the departments. But then if it's an independent body, then a lot of extra work will be involved. And the only exception is in the Netherlands, where it's an independent body. But then the fact that they have been able to do it, they have to make a lot of sacrifices. For example, in terms of the applications, they will have to do it by way of a fixed sum. That is, there would be caps on the amount that they could apply for, and only then were they able to come up with the budget, and then they can apply for funding from the administration. Now we do not have any cap at all, so it's entirely demand-driven. So if it's done by an independent body, then it's so complicated and difficult to run that it would be almost impossible. The last point about the possible conflict of interest. Have you heard the question clearly? Well, in our recommendation, we also refer to that. Well, the advisory body or the advisory committee as the regulatory body will be looking at how it could discharge its duties independently. But then perception-wise, all right, for the official solicitor is a very small department, and we've also consulted many from the legal profession, and they do not have very strong views about this because most of these cases are not very controversial. They are and they only involve a very small team of lawyers, a dozen or so. And we have also sought external advice from the legal profession. And that's why if you look at the actual operation of the department, we do not see very serious needs for it to be turned independent. All right, because of the time pressure, all right, only Mr. Kwok can ask question. 2 minutes. We will have to wrap up our meeting. Yes, I'd like to put this to the HAB officials. According to the figures provided by the Judiciary, at the High Court for civil cases, well, for litigants without legal representation, some 30% are not represented. It's a very high figure. And also for the appeal cases to the registrar, well, some 67% of the litigants were not represented. And then when it goes to the appeal court, it's also very worrying. Some 54% of the litigants were not legally represented. I hope that you can make a promise that you would review the coverage of legal aid as soon as possible, and also the issue or the problem of the SLAS. Please give a brief response. Yes, Mr. Kwok. Well, for unrepresented litigants, well, actually, the CJ has appointed a civil justice reform group. They have proposed that there should be a pilot scheme on unrepresented litigants, and in fact, in March, we rolled out the pilot scheme. And before we rolled out the program, we have actually provided a paper to this panel to explain the situation, and we'll be looking at the experience that has been accumulated. We have a working group which is chaired by Justice Pankin K. All right, it has been up and running for several months only, but then by the end of May, if you look at the office that has been set up for this scheme, some 200 plus litigants have been given legal advice. Well, this is a very good service, but then we will be collecting information about this because, well, there might be different reasons for a litigant to be not legally represented. Yes, I understand that the legal profession has asked us to review the OLAs and SLAS, but then the fact that the litigants are not legally represented might not have anything to do with the coverage of these schemes. For various reasons, they might choose not to be legally represented, but then the pilot scheme would be able to help them. All right, we've already had a very adequate discussion on this, and we also discussed the issue of whether or not there should be a cap on the budget. I'm sure you all understand that why members also have this perception. And I'm afraid this issue cannot be resolved within this short term. But then in terms of the direction, if there is anything that can be done to improve the coverage of legal aid, well, we have discussed that many times. And I hope that you can take on board our views. All right, so much for today's discussion. Yes, the Deputy Secretary promised that she would go back and she would come up with a paper to explain to us and the two legal bodies on what's meant by a cap on the budget, and whether or not they would be prepared to accept a cap on the budget if it's turned independent. All right, can they provide a further paper? And if the Law Society and the Bar Association like it, they can also provide us with further submissions. Yes, please do provide us with further information in order to address some of the issues raised by the deputations. All right, our meeting is adjourned. Thank you for joining.